Hello, and welcome to the annual Cuyahoga County Ethics presentation. This will fulfill your annual ethics training obligation. The Cuyahoga County Ethics Code was passed by County Council in 2010, signed by the County Executive in 2011, and has been amended since. While the updated codes do not touch upon all ethical matters governed in the Ohio Revised Code, every subject matter that is addressed in the county's code is intended to either meet or exceed the ethical requirements mandated by the Ohio Revised Code. The county code requires that all employees, elected officials, board members, volunteers, lobbyists, and contractors undergo annual ethics training. Participants are required to sign a statement acknowledging that they have undergone training and that they have read, understood, and agreed to the information in the ethics code. Again, you will be signing this acknowledgement electronically at the end of today's presentation. Before we look at the ethics code, let's look at why the ethics code is important to both you as a public employee and a tax-paying citizen. The ethics code was designed to ensure public employees are not influenced by personal, financial, or other interests when they spend public money or make decisions on behalf of a public agency. For example, when you shop at a grocery store, you may have noticed that the weight scales are inspected by a public employee. The ethics code tells you that the public inspector was not an owner or relative of the store owner, and the inspector had no personal, family, or business gains associated with the inspection. In other words, all taxpayers have the right to expect that public decisions and public expenditures are objective and made with the public's best interest in mind. The ethics code has three main purposes. First, to set minimum standards of ethical conduct for all of us. Second, to provide a process to disclose unethical practices. And third, to establish penalties for those who violate the ethics policy. Under the code, no elected official, employee, or board member shall solicit or accept any gift where the gift is intended to influence the elected official, employee, or board member in the performance or non-performance of their official powers or duties. The key question is, could the gift create an improper influence on the decision an employee, elected official, or board member is making? A vendor providing a promotional item to promote their product, like a pen or a keychain, most likely couldn't provide a substantial or improper influence. But remember, it is always better to be safe than sorry. Soliciting or accepting improper compensation or gratuities for regular duties is also prohibited under the code. This means that it is illegal for an employee to request or accept compensation other than his or her own county paycheck and county benefits to perform job duties. It is illegal for anyone to promise or give an employee compensation to perform his or her regular duties or to supplement an employee's compensation. Anyone convicted of soliciting or accepting improper compensation or gratuities for regular duties or employment favors is guilty of a first-degree misdemeanor, subject to penalties and fines, and disqualified from holding public employment anywhere in the state of Ohio for 7 years. All taxpayers have the right to know that public servants are required to act in the public's best interest rather than their own or those closely related parties. As public employees, we have conflicts of interest when our ability to be objective decision makers is impaired by our own interests or the interests of our family member or business associates. Keep in mind that conflict of interest is not in and of itself illegal. In fact, conflicts are normal because we have families and friends, possible outside business investments, property interests, or other connections to our communities. Any of these connections could result in a conflict of interest. The Ethics Code does not prohibit us from having such conflicts, it prohibits us from acting on these conflicts. Whenever an employee is faced with a conflict of interest, the employee is required to abstain from anything that would benefit the employee or their family members or business associates. In fact, the proper action in a conflict of interest situation is recusal. The Ethics Code specifies political activity that is prohibited by county employees. Employees are prohibited from knowingly making a campaign contribution to or soliciting funds for their own elected employer for whom they work or confirming authority. Employees can register and vote, express opinions, make contributions to candidates they do not work for, circulate nonpartisan petitions, attend rallies, sign nominating petitions, have political materials displayed at their home or on their property, wear political material on themselves or on a personal vehicle, and serve as an election day poll worker. Employees cannot participate in any decisions involving a benefit to relatives like hiring, appraisal, promotion, or approving leaves of absences. Individuals can't accept employment in a department in which a relative has supervisory authority. If an employee becomes related to a supervisor in the same department, that employee would be transferred. Taxpayers have the right to know that when jobs are awarded, they are given to the most qualified candidate, not the most connected candidate. The Ethics Code prohibits the misuse of county resources for political materials or conducting non-county business. The misuse of resources, however, will be governed by the county's IT and human resources policies. Under the Ethics Code, county officials, employees, and board members are prohibited from selling goods or services to the county except through the competitive bidding process. Any contract awarded in violation of the code shall be void and unenforceable. Misuse of official position also includes representing your opinion as the official position of the county or withholding a document that is considered a public record. Supervisors are prohibited from requiring that employees perform personal tasks that do not further the county's interest, perform work outside of the course of normal employment, or purchase goods and services for personal purposes. Other examples of misuse of official position would include ordering goods or services without authorization, or accepting county funds to attend a conference, then not attending the conference and not refunding those monies back to the county. Divulging confidential information is in violation of the code. It does not matter whether the information is digital or on paper. Confidential means exactly that. No information designated as confidential shall be disclosed. In addition to the Ohio Revised Code and the County Code, certain conduct is prohibited by the Federal Civil Rights Act of 1964 and other codes. This includes favoring or discriminating against anyone because of their race, religion, age, ethnicity, gender, sexual orientation, disability, or political affiliation. No employee may harass or make unwelcome advances to interfere with job performance, create a hostile work environment, or attempt to make a person's submission or rejection of advances a condition of their employment status. The Inspector General is the investigative officer for the county and conducts all investigations pertaining to the County Ethics Code. After an investigation, the Inspector General may issue letters of notification, admonition, or censure, recommend suspension of an employee, suspend an organization's right to bid on or obtain county contracts, or refer violators for additional ethics training. The County Inspector General may also refer violators to the Ohio Ethics Commission or to the appropriate code enforcement agencies. Under the Ohio Revised Code, a whistleblower is defined as a person who reports possible crimes or violations. The Ohio Revised Code contains specific protections for whistleblowers. It specifies that no one shall take disciplinary action, such as removal, suspension, transfer, demotion, or withholding a raise or promotion against a whistleblower. In Cuyahoga County, whistleblowing employees who feel they have been retaliated against should consult their collective bargaining agreement, or CBA. Employees who do not fall under a CBA or whose CBA does not address whistleblower retaliation must file an appeal with the Personnel Review Commission within 30 days. Certain whistleblower responsibilities are detailed in the County Ethics Code. For instance, employees, elected officials, or board members who possess actual knowledge of a violation shall inform the Inspector General within 5 days of discovering the violation, unless the individual knows the violation has already been reported. No person shall retaliate against any individual who, in good faith, has filed a written report or expressed in writing their intent to report a violation or suspected violation of the code. Any employee who believes he or she has been subjected to retaliation for having filed a complaint should report such retaliation to the Department of Human Resources. The Ohio Revised Code specifies a penalty for those employees who file false or frivolous complaints. Those who purposely, knowingly, or recklessly report false information are subject to discipline. Under the County Ethics Code, employees are required to cooperate fully with any investigation by the Inspector General, the Department of Human Resources, or the Personnel Review Commission. Cooperation includes producing any information requested by the investigating agency unless that information is not subject to disclosure. The Ethics Code states that employees shall not engage in secondary employment that is incompatible with their county duties. Prior to accepting any secondary employment, an employee must complete a secondary employment disclosure form and submit it to both Human Resources and the Inspector General for advice. A secondary form must also be completed if an employee has any fiduciary, meaning legal or ethical relationship of trust, or pecuniary, meaning financial relationship, with an agency funded by the county. This obligation is not limited to a financial relationship only. Also, a secondary form must be submitted if secondary employment duties change at any time. Secondary employment forms are available on the Cuyahoga County Inspector General website. If the Inspector General rules that an employee's secondary employment is in conflict with the employee's county duties, the employee will either terminate that secondary employment or face dismissal from the county. Additional questions about Ethics Code requirements can always be found online at the Cuyahoga County Inspector General's website. Other human resources questions should be addressed to your human resources representative or email humanresources@cuyahogacounty.us. All county executive employees who have relatives or business associates employed by the county or business interests doing business with the county must have a completed nepotism statement and conflict of interest form on file. If you have filed a form in the past and the information listed on the form has changed, you must update this form. Forms are available on the Inspector General's website. Congratulations! You have now completed your annual ethics requirement. By clicking the screen as directed, you are verifying that you have read, understand, and agree with the information in the Ethics Code. Remember, as always, falsification of a signature, including an electronic signature, is grounds for discipline. Thank you for your cooperation and for your work on behalf of the citizens of Cuyahoga County.